Thank you. Please be seated. We are here this morning for the submission of 3 cases, and our first case for oral argument is Jones versus Lindell and others. Looks like the parties are ready. Mr. Ross, you may begin.
Thank you, Your Honor. May it please the court. I'll briefly begin with just some basic facts about this claim, and then we'll focus the rest of my argument on the one single issue that we're asking the court to reconsider here as part of this appeal. So this case stems from a hysterectomy surgery that was performed at Broadlawns Medical Center on December 21st of 2021. During that surgery, the defendant, Dr. Lindell, failed to properly identify my client, plaintiff Linda Jones's ureters during the surgery and ended up injuring them. Following surgery, perhaps because of the impending Christmas holiday, Dr. Lindell and others failed to address properly Miss Jones's post-operative complaints about pain and other issues that she was having that would have alerted them to the fact that there was an issue. She ultimately was discharged against her will, went home, called 911, was taken in an ambulance to Mercy Medical Center, where they immediately realized the problem and took her in for emergency surgery to fix the issue and address the obstruction and injuries to my client's ureters. There's only one issue for the court to determine today and to analyze, and that is whether the medical fields of urology and gynecology are substantially similar under Iowa Code Section 147-139. What happened in this case was that as trial was approaching and pretrial motions were being filed, the defendants filed a motion arguing for the court to strike the expert report of Dr. Wayment, the defendant's expert witness in this case. Dr. Wayment is a board-certified urologist, and he had offered opinions both about the surgery that was performed as well as the deficiencies that he perceived in the post-operative care that I just mentioned. The only argument in the motion was that under Code Section 147-139, the expert's report should be stricken because he's not in a substantially similar field as gynecology, which was the field in which Dr. Lindell, the defendant, was board certified. What ended up happening, and what we've seen happen in these types of cases now under this, the new wording of Section 147.139, is that it was treated as a pseudo Daubert-Frye motion. So instead of the court focusing on the only issue that was before it, which is, are these two medical fields substantially similar, the court reviewed the deposition testimony that was provided by defendants in the motion. The court analyzed arguments related to the experience and the training of the doctor and got solely fixed on this doctor and his qualifications. So it was treated as a Frye-Daubert motion. Now, ultimately, the court did issue a ruling saying that under this, under 147.139, that the fields were not substantially similar, but there's no reasoning in the court's order to explain how it came to that decision and why those two fields were not substantially similar. So while the defendants were arguing about the qualifications of the doctor or different admissions that he made about his training or experience during his deposition, we tried to gear the court toward the question of, these are two medical fields, take the doctors out of the picture, take these two medical fields and determine, are they substantially similar, which is what the statute requires. And as part of that discussion, what we provided to the court, which was not a Daubert-Frye analysis at all, was some information about the two fields that shows a significant overlap in why these two fields are significant. For example, we explained to the court both of these fields perform hysterectomy surgeries like the one that was done here. Both of these fields operate on the ureters, as was done in this case. Both of these fields provide post-operative care after a surgery like this, which is what our doctor opined on. We even went so far as to show that the two fields, gynecology and urology, they even, yes, Your Honor.
Interrupt. Just you've said field several times, and I just want to make sure that I understand what issue we're talking about, because the briefs talk about field and they also talk about specialty, and the statute seems to draw some distinctions between the two. So would you mind addressing that? Do you think field and specialty are the same, or are they different, and how does that work?
That they're primarily the same. Both words are used in the statute. So under subsection 1, it says the person is licensed to practice in the same or substantially similar field as defendant. And then subsection 3 says if the defendant is board certified, which is in this case they are both board certified, in a specialty, the person is certified in the same or a substantially similar specialty. So while both are used, I don't see a distinction. I see that what the focus is that it's same or substantially, and then the qualifier, which is the medical practice or the field of the practice.
Let me ask you this. It does seem like there could be a difference in the sense that we're talking about licensure in the same field, for example, on number 1, right? And there isn't a separate, is there a separate licensure for urologists and gynecologists, or are they both licensed as doctors?
Doctors. The subsection 3, which begins to talk about the board certification, that is where there are separations. There is a different board certification for each. Yes.
I'm a little troubled by your position. As I read this statute, it has these different requirements, but I think kind of the overall theme of it for the expert is if you want to talk the talk, you have to walk the walk. And as I understand it, your expert, Dr. Wayman, is not someone who would perform hysterectomies, and therefore to critique someone else's performance of hysterectomies, that seems to maybe, I know we don't like to talk about spirits of the laws, but it seems to be maybe different from the spirit of what this law is talking about.
How I would respond to that, Your Honor, is to say, if defendants would have filed a motion to say, we want to limit him, he can't talk about the surgical procedure itself because even though he's performed some of these, it's not his day-to-day surgery. He repairs ureters, which is the injury in this case. But let's say that the court said, I don't find that he's done enough hysterectomies that he can opine on the surgical technique. He still is able to opine on postoperative care for a ureter injury, which is what he also talks about. So had they filed a motion to say, under Daubert Frye or Iowa's equivalent, that we're going to limit him here, but we'll allow him to testify here, that would have been perfectly fine. But that's not what they did. They filed a motion saying strike his report.
Statute a little bit different in the sense there are some states that have these statutes, but the relevant inquiry is what is the specific procedure or specification of negligence at issue, and if that person's competent to testify on that, then that's okay. But our statute draws a categorical rule that says they have to be board certified in the same specialty without any mention of what the specification of negligence is. So aren't we really just making a categorical determination on is board certified in urology substantially similar to board certified in OBGYN, regardless of what the procedure is at issue?
That's correct. And I feel like the court went to
of post-operative care even relevant. It's a categorical determination, right?
We believe the court just skipped that analysis altogether. And instead of looking at whether the two specialties are substantially similar, instead of looking at the fact that, as mentioned in the briefing, that even the University of Iowa Medical School trains their OBGYNs through, they partner them up with urologists who train them in these procedures to show, look, Your Honor, there's overlap. These are substantially similar fields or substantially similar specialties. The court went the direction that you're saying, which was to say, well, under the testimony that was given here, it looks like he doesn't perform these surgeries, so, and then went on to say in his same order, the district court went on to say that that analysis isn't correct, that we're not looking at that. But that's exactly what the court did, is they looked at those issues. And I'm just saying, under this statute, under the statute that was used to disqualify our expert, the court needed to make a finding, a determination that urology and gynecology are not substantially similar. And it didn't do that. And that was the argument, that the only argument that was made by defendants was to say, under the statute, these aren't the same. And the court even went to say, the statute must be contemplating something other than the same because it says same or substantially similar. But then the court went on to rule that it had to be the same.
Broad factors that we should be thinking about? Is it when they're working on the same body part, when procedures are similar, when their training is similar? What sort of, unless it's a fact by fact, every case is going to be different. Are there any broad principles that we should be applying to answer this question?
One of the problems that we're seeing is courts have only used this statute to exclude. They are looking to say, look, there must be something other than the same. So there's got to be something else we can look at here to say these are substantially similar, but doesn't provide that. And the court didn't address that and didn't go on to say that. So what we provided the court with really no guidance, as you're mentioning, there's really nothing in the statute to guide us. There's no case law even to guide that analysis, was to go on to say, look, we've identified these ways that they overlap. This is just to show the court there's so many similarities with the body parts, with the procedures, with the training, with the clinical studies that are done, with the articles that are published. Our own doctor published articles on hysterectomies. There's so much overlap that for the court to just exclude the expert without making any determination that the specialties are or are not substantially the same was an error.
Sense to me, and that's what courts in other states are doing, looking at the procedure that went wrong and whether the experts for the plaintiff and for the defense and the defendant doctors overlapped and they have that expertise. And I think that you would have won under the former version of this statute. But do you have any cases interpreting the statute as written now from other states that would use this overlap approach?
We did not look outside of the state because the statute is so unique here in Iowa. But I would agree, the court said in his order that this isn't about, even kind of said plaintiffs are misguided by pointing out the different things that their own doctor has done experience-wise or education-wise, because that's not the analysis. The analysis is, are the specialties substantially the same? But then the court didn't address the question that was identified, and which we believe was identified.
Possible to contact somebody from one of these boards to put on evidence about the criteria by which somebody gets certified in the specialty and provide guidance. So like on this record, it's not clear to me. I think there's some information from a website about the University of Iowa and how they train physicians. So what evidence is in the record from, other than this website, that indicates that when the boards are certifying physicians in these two fields, that the medical profession considers them substantially similar?
Really, I mean, there's that terminology. Yeah, just
similar, but their practices look very different on this record, which would indicate to me that these are not substantially similar fields, because it doesn't look like there's any overlap in what they actually did in their medical practices.
To address that second part, I would say there's significant overlap that we identified where, for example, they're trained together, they publish together, they even collaborate on subspecialties. So we did talk about that.
Perform this procedure at issue, correct?
Yes. He has done hysterectomies. That was raised in there's deposition testimony to that was raised in the initial briefing, that he's been the one who's performed it. He's been the one to make the first incision in a hysterectomy procedure. It's just not his day-to-day procedure. It's not what he focuses on.
After medical school?
Yeah. And so So just, and then just to kind of go back to what you said, there's cases that are cited by the defendants in their case, in their briefing, that talks about a radiologist, for example, isn't the same as emergency medicine. Like, there's some real softballs out there, and I understand that. And I understand that we would say, a court could easily say, look, I'm not going to allow a hospitalist to opine on whether or not a radiologist did their job right, or an ER doctor to opine on whether or not a gynecologist did their job right. But this isn't that case. This is a case where there's so much overlap and so much collaboration that we believe we've met the standard here, but there are no courts who've made this distinction, who've made a ruling on this, which is why we felt it was appropriate for appeal, because the courts are not, when there is a close case like this, the courts don't have anywhere to go, essentially, on that issue. And we believe the court overly focused on qualifications, treated this like a Daubert motion, instead of answering the question at issue, which was, are these substantially similar specialties? With that, thank you.
Mr. Moser.
Thank you. May it please the court, counsel. I'd like to start correcting those factual statements that you asked about, Justice McDonald. But first, let me introduce myself and my client. My name's Joe Moser. I'm from the Finley Law Firm here in Des Moines. I represent Dr. Larry Lindell and Broadlawns Medical Center. As has been discussed, Dr. Lindell is a board-certified OBGYN, an obstetrics and gynecological provider. Plaintiff's expert is a board-certified urologist. He does not practice as an OBGYN. His actual testimony, and I can point to specific testimony, is page 27, lines 4 to 7. He admits he is not an OBGYN. He admits he has not practiced as an OBGYN in the last 5 years prior to the treatment that's placed at issue. That's at page 32 of his deposition, lines 9 through 12. He testified that he has never performed an exploratory laparotomy and total abdominal hysterectomy and bilateral salpingectomy, which is a procedure at issue in this case. That's at page 17, lines 8 to 11. He testified he was never trained in performing that procedure. That's also at page 17, lines 12 to 13. He testified he would never even be in the surgical suite when this procedure is performed. And Your Honor, there's plenty of other testimony that's in the record before this court as part of the statement of facts that the district court considered in determining, as this court should affirm, that these are separate, distinct, unique, and not substantially similar fields of practice, and that these specialties are not substantially similar.
He make that determination? And I understand he didn't practice in the area, but that doesn't answer the question of whether he could have, or whether the specialties are substantially similar. What factors would we look at to make that determination?
And I think we need to break down the statute piece by piece to get to that determination. So if you'll bear with me, the first part of the statute, and Justice May, you asked about this, is that the person is licensed to practice in the same or substantially similar field as the defendant. So I agree with counsel that we are looking at the defendant and their practice to see if the plaintiff's expert is substantially similar. It's not as broad as licensed in the field of medicine. And we know that and can determine that because to rule that broadly, or to find that the statute is interpreted that broadly, it would render field meaningless. And field, under as defined commonly and in the dictionary, is an area of practice within a profession. And that's consistent with this court's other rulings, prior rulings. Go ahead.
This, we can circle back to this. I want to get to the issue about specialty. But so if you'd address that directly, that'd be great.
Talking about specialty in the board certifications, I think we can look to several things, Your Honor. The specialty, and on the record before this court, we have the boards themselves providing what is required to be specialized in that field. So an OBGYN, for example, has to go through a residency and a fellowship in obstetrics and gynecology. A urologist does not. The field of the information that's in this record is from those specialty boards and what that practice and experience is required to become licensed, to become board certified in that specialty. So I think we can look to that for the specialty certifications.
I mean, you do, I think, a fair amount of this medical malpractice work. Substantially similar has to mean something different from identical. Could you give me an example of two fields that would not be identical but would be substantially similar?
Justice, I think that one good example is in subsection 3 in discussing the specialties themselves is the statute expressly recognizes two different certifying boards. We have the American Board of Medical Specialties, the AMBS, and the AOA, the American Osteopathic Associations. They have two separate paths with different qualifications for the specialists that they certify under those. Made myself a nice little chart of the two different
Same field, they just happen to be DOs or MDs.
highlights that they are not the same because they have different qualifications, different requirements, but they are substantially similar. They're not identical, but are substantially similar.
Saying is the person would still have to be board certified as an OBGYN, but substantially similar would just mean that they were certified by different boards, but in the same substantive area.
Example, and I think that that's
Or assume it's the same board, but they're a specialty in two different specialties. I just want an example of what would be substantially similar in that context.
I think that would be an inquiry that is more case-specific because there is some overlap in specialties. One overlapping specialty might be internal medicine and family practice or family medicine. That's one that we commonly see. But in those cases where they are board certified, determining whether those specialties are substantially similar, we can go back to subsections 1 and 2 to look at their fields as whether they are substantially similar, because they might not be. You might be an internal medicine physician who practices hospital medicine in a hospital setting, and you may be a family practice physician who practices in a clinical outpatient setting, in which case their fields would not be substantially similar, even if the specialty training might be under the board certification.
The specialties, I don't want to talk about fields. Looking at the training required is not particularly helpful to me, at least the way you've presented it, because you've said, well, to be a board certified OBGYN, you have to do X number of years of residency as an OBGYN, and to be board certified as a urologist, you have to be trained as a urologist. That doesn't answer the question in my mind of whether OBGYN is substantially similar to urology, because you're kind of assuming the answer to the question with the factors. So for a non-doctor, how do I determine whether an OBGYN is the same as a urologist or substantially similar?
When we look at the statute, and particularly the legislative history, this is in Iowa, the modification, the complete change of Iowa Code 147-139 is intended to be exclusionary. It's intended to have limited exceptions. We want same versus same, or very similar versus very similar. As Justice Mansfield said, if you walk the walk, you talk the talk, right? That's what we want, people who are in the same specialty doing the same thing.
Statute, I understand the structure. I want to know what is substantially similar to a non-doctor. What do I look at to make that determination?
Specifically, you have to look at what that specialty requires. And you might need testimony from someone from that board. I think you can look towards what the board requires in order to be certified in it and see if those two boards are substantially similar in their training requirements, their education requirements, their experience requirements, the type of procedures that are performed exclusively by those specialties.
District court can decide on without an expert witness?
Without an expert to testify as to that specialty?
Without an expert to talk about whether they are substantially similar?
There are reliable sources, including the boards themselves, that the court can look to for evidence. I think that the testimony of the expert whose qualifications are at issue about what their specialization requires, what training, education they did, and whether it is or is not substantially similar to the field of medicine, to the specialty that is at issue for the defendant.
Also, after the amendment to the statute, does the current language of the statute allow for a test that would look at whether the expert performs the procedure at issue, and if the standard of care for performing the procedure is the same for the plaintiff's expert and the defendant doctor?
Is no, Justice Waterman, and why is because when Iowa Code 147-139 was changed in 2017, they took that section and deleted it in its entirety and wrote a new and substantially different qualification requirement. So it's not enough to have some overlap, to have some experience in the same procedure or medical issue that is at issue in the underlying case.
Expert had been certified in the subspecialty of urogynecology. Would that be substantially similar to OBGYN certification?
That would be a very good argument for their specialty being substantially similar, because it would then relate to obstetrics and gynecology, and to become subspecialized in that, you have to go through obstetrics and gynecological training. That's part of the requirement of that specialization.
What substantially similar could mean that there are these subspecialties where you have kind of cross-training between two different specialties. Is that a potential answer?
Potential answer. When boards recognize overlap and train jointly to issue a joint specialization between, for example, obstetrics and gynecology and urology, that would be an indication of substantially similar in certain scenarios. Fortunately, that highlights for us why Dr. Wayment was not qualified, because he did not have that joint specialization. He did not go through that training. There is no evidence that he had any of that experience, education, training in that specialization. And so, Your Honors, I think that as we return to breaking down 147-139 in a very simplistic form, I would say that subsection 1, licensed to practice in the same or substantially similar field, is being licensed in a same or similar area of practice within the profession of medicine. That subsection 2 relate.
Are there separate licenses for urologists and OBGYNs? Is that what you're saying?
In terms of their specialization, yes. We're more talking about, are they practicing in the same area, in the same field of medicine?
There's a separate license.
License in the state of Iowa.
That causes a real problem for me on section 1, saying that there are two different fields. If they have the same license, it said license in the same field.
There is difference in terms of their practice qualifications and what they are permitted to perform in the scope of their practice. It's not a separate license. And so we have to read license to practice in the same or similar field as a whole phrase to understand and give meaning to that. Because if it just said licensed, the legislature could have just said licensed. They could have referred to section 148. Sorry, Justice.
Because the statute covers healthcare providers, and the term healthcare providers covers people with all different kinds of licensure. It covers nurses, doctors, psychiatrists, podiatrists, et cetera. So in that sense, there's only one kind of license for doctors, and either you have it or you don't. I'm not sure why. I mean, it's making a distinction, so you can't have a psychiatrist talking about this or a nurse talking about a doctor. But if they're have the same actual license, I'm not sure why we need to inquire any further.
We look at, in the first unnumbered paragraph at the beginning of 147, 139, it does reference healthcare provider as defined in section 147, 136A. It could have repeated that language in subsection 1, but did not. So it needs to mean something different. It would also render subsection 4 completely superfluous because it says if you're a doctor, it has to be a doctor. Right, so we would have unnecessary duplication and superfluous language in subsection 4. So I think we have to look at license in the same or similar field, substantially similar field as a whole phrase to render it meaning. And as Justice Mansfield discussed in the Miller versus Catholic Health oral argument discussing this same statute, we have to render similar meaning to that phrase in both subsections 1 and subsection 2. And the statute only makes sense, only functions as intended, as demonstrated by the legislative history, if we render that meaning an area of practice within the field of medicine. So subsection 1, we have that area of practice within the field of medicine. Section 2 is the time that they have practiced in that field of medicine. And then subsection 3, we get to that board certification. And an expert must have all three. And in our case, the expert had 0 of those and was not qualified. The district court reached the correct conclusion. We ask that this court affirm. Thank you.
May it please the court. Counsel, I'll first address any questions that have come up. I know there were quite a few questions. Is there anything before I?
2 experts. If you had named 2 experts, one OB-GYN, one urologist, we wouldn't be here today, would we?
It goes to show that this is almost unworkable. How is a plaintiff to know where the line is drawn? Oh, you can have an OB-GYN, but you can't have a urogyn, or you can't have a urologist. It's just.
One, are you?
You're not. But here we thought we had a doctor who's performed hysterectomy surgeries. He's performed ureter repair surgeries, which is exactly what happened in this case and what was required because of the injury. This is what he does day in and day out. We thought we had the right expert. And so I do believe there's a little bit of an element of surprise when you have a statute that's so broad. How is, as has been
Because something happened during the hysterectomy?
true, however, the bulk of his opinions, and we made this argument in the district court, the bulk of his opinions are about the postoperative care, the complaints that the patient was having that went unaddressed. And I think if this had been a Daubert or a Fry type hearing, the judge would have said, yeah, he can testify about those. He's perfectly qualified to testify about why the doctor missed all these subsequent things. But the case was thrown out because of this substantially similar language that we still don't have an answer. And the court has raised us, what is substantially similar? We still don't know, and we don't have a formula, and a judge doesn't know where to go. We tried to show overlap. It seems to me that defendants are even conceding that had our expert performed this procedure with his current licenses, with his current board certifications, he could have done these procedures. Had he done them on a more regular basis, then they seem to be saying we would just concede that he's qualified. But isn't that the very issue that we're dealing with here, is that the judge said, it's not about the qualifications, I'm looking at whether it meets the statute of same or substantially similar. And that was the reason that he was excluded, just because of a determination that it wasn't substantially similar.
Is there a difference between a specialty and a subspecialty? And so there was some discussion about a urogynecologist. Is that a subspecialty of a urologist, or is it a specialty itself?
Of both. So what ended up happening with urogynecologists was urology and gynecology, they collaborated, because the fields are so substantially similar, they collaborated on a subspecialty that would address specific urinary issues, like incontinence, for example. And so they collaborated, because their training overlaps, to create a subspecialty, which we defend.
Certified by what board then? It's its own.
Yeah. And so we believe that goes to show these two fields who are so similar are able to jointly create another field. Again, if this were a case where it was a nurse versus a radiologist or something like that, I would totally understand. Those are no-brainers, and that's what we see in the cases that have been cited. What we don't see is a case where a doctor is licensed and even experienced in performing a surgery, but then the fields are determined to be not substantially the same. And that's the issue that we raise here.
What is your response to the question about whether or not a district court needs an expert to discuss what these specialties are?
At this point, I would honestly believe so. When we filed this case, we didn't believe so. But seeing how complicated this issue got, it does add another element to a case to say, well, now we need an expert on medical fields. I think what ends up happening is when cases are published addressing this issue, for example, there's no case on point, I believe, to the degree that we're dealing with today. After that's published, maybe that provides guidance and attorneys don't file cases where it's such a close call, or they just say, I'm not even going to deal with it, I'll just go with the same. But the statute says same or substantially similar. It seems to say we're not just limiting it to the same, we're opening the door to substantially similar, but then provides no guidance on that.
OBGYN and urology, what are some other specialties that you think would be substantially similar but are not the same?
I would say oncology would be substantially similar to some fields. So for example, if you were a dermatologist and an oncologist and you're treating skin cancers, I could see where a judge could say, well, these are substantially similar, you're treating these same conditions as we have here. There's probably some elements of neurology and orthopedic surgery that might be the same, where you're treating the spinal cord. Those are just some examples that come to mind. Thank you, appreciate your time.
Versus Lindell and others is hereby submitted. We'll have a brief pause while the next case gets ready. McQuillen versus West Side Transport. Okay. McQuillen versus West Side Transport is ready. Mr. Weinhardt, you may begin.
Thank you, Your Honor. May it please the court, counsel. Mark Weinhardt and Jason Smith on behalf of the defendant appellants West Side Transport and Clifford Takis. This is a car-truck collision case that produced a jury verdict of $26 million in compensatory damages. Both drivers were negligent in some measure, and the fighting issue in the case is the allocation of fault between them and whether, in fact, the plaintiff was at fault by the majority and thus should not take any compensatory damages. A repeatedly erroneous closing argument greatly skewed the fault allocation between the parties, and we think merits reversal. We submit that this case presents the question not only of whether justice was done here, but it presents a precedential question for the control of attorney conduct in closing arguments in Iowa. The first closing argument error concerns the specifications of negligence applied to the defendant driver, Clifford Takis. The closing argument is basically divided into 4 sections. First, the negligence of Mr. Takis. Second, the negligence of plaintiff McQuillen. Third, an analysis of causation and comparison between the two. And finally, damages. In the first quarter of the argument, the analysis of Mr. Takis's negligence, there was a series of PowerPoint slides placed in front of the jury. The one that we have here, the visual aid, and all of you have a copy of it in front of you, is at page 15 of our brief. It is the last...
Interrupt for just a moment for logistics. I know how these things work when exhibits are prepared ahead of time, especially you can tell. I used to use a marker on white paper. You guys put a lot more effort into it. So was this exhibit already prepared, and then there was a hearing, maybe a motion in limine, and the judge said, no, that can't come in about speeding? And then how much time was there between that decision and go time? I'm just wondering, was there overnight? How much time was there between the ruling and go time?
There was not a lot of time between the ruling and go time, but this was not disclosed in advance so that there was an opportunity for objection. So the argument happens, this goes on the screen, and they start talking. At that point, the 3 of the specifications of negligence that are on that chart were not in the case.
Counsel, was there an objection at that point, or to the chief's point, was there a request to see these slides in advance that at any point?
There was a request to see them in advance. There was not a contemporaneous objection as the slides were being made. There was an interruption in the summation argument of the plaintiff after he had completed the first 3 portions of the argument and he was in damages. During that interruption, there was a motion for mistrial addressing this issue as well as the expert witness issue that we will discuss next. And the district court found that this was objectionable, but declined to issue a mistrial. But he actually cautioned the plaintiff's lawyer, Danielle Rodriguez, and told him not to say anything that would mislead the jury into understanding what the specifications of negligence actually are that are being submitted. And
to the jury, and jury pretend like that didn't just happen?
not. And in fact...
And rejected by West Side?
So no, there was no offer of a curative instruction. There was no request for a curative instruction.
Would have been an easy curative instruction or a response by West Side in their own closing when you've got the jury instructions that say these are the 3 or however many it was that are allowed. So please disregard what, the fact that there are 5 in the plaintiffs. Why was that not an appropriate way to handle it?
I think most importantly, the defense is relying on this court's law, which was established in Kinseth but other cases, that a closing argument does not require a series of contemporaneous objections, but rather the objection can be made in a mistrial motion, which they did at the first opportunity.
I mean, there are some things during closing that happen that just have got to be addressed. And you know it when you see it. If this is so critical to your appeal, wouldn't that have been one of the things that you would have objected to during closing?
I wasn't there. We were retained post-verdict, but...
I mean, your client, yeah.
Perhaps better practice, but is it dispositive of this appeal? Is the reliance on the procedure this court has approved, which is a motion for mistrial at a suitably early opportunity?
I agree, Mr. Weinhardt. Our cases say that preserves error, and error is definitely preserved on that. I have no problem with that. But still, in weighing the prejudice, the judge considered the fact that there wasn't an objection made at the moment. Was that inappropriate of the trial judge to do that?
I think that the district court needed to make a prejudice determination based upon whether or not the misconduct here had the effect of prejudicing or of changing the outcome. We have 2 problems with that. The first is that the district court when it analyzed this in post-trial motions, analyzed this using a 5-factor test having to do with whether or not error resulted or error required a reversal of a criminal conviction. Criminal convictions are purely binary events. There's a conviction or there is an acquittal. But here, and this is without any contest from the plaintiff,
The law, it's not exactly binary. There are lesser included offenses. There are multiple counts. There are all kinds of, shades. Just like here, there are shades of comparative fault, right?
I would submit, though, that the allocation of comparative fault is more in the hands of the jury discretionary. It's almost as though juries had the opportunity to perform the sentencing function at a criminal trial, which they don't. And
We move on. If the defense attorney, for whatever reasons, maybe just didn't want to make it a bigger deal, that's sometimes why nothing gets said. You just don't want to enunciate what just happened. Are you saying it was error for the court not to sua sponte say, you know what, jury, disregard that? Because the instructions, and to include an instruction, of course, are you saying it was error for the court not to do that?
the error that we appeal is the failure to grant the mistrial motion, and when the full record is done, the failure to grant the motion for new trial. And that's what should have happened, and that's what, and that's why we believe it should be reversed and remanded for a new trial here. One of the
Doing for abuse of discretion, so don't we give a lot of leeway to the trial judge who has the front row seat for all this?
There are cases, however, where discretion is abused, and this is as bad a one as I think this court has ever considered. This court found that the error in Kinseth, which was a distraction from the jury's core function, was sufficiently bad to reverse. In this case, the error was a distortion of the jury's core function, which we submit is worse. And one of the ways that we know this was so prejudicial is that the lawyer who did it, Mr. Rodriguez, had been doing this for 40 years. He's tried 150 jury cases. He is immensely successful, and it is inescapable that he did this on purpose. In fact, he returned, even after being admonished at the end of his summation argument, he returned to this parking specification that had been specifically directed out of the case. And then, and we didn't put this in our brief, we caught this in oral argument preparation, that in the rebuttal argument, he again, this is at pages 83 and 84 of that transcript, again comes back to the speeding thing and the parking thing, both of which had been directed out of the case. Why does he go back there? He goes back there because he knows what motivates a jury. He knew that those things would matter to the jury.
You meant in chambers with the other attorney?
In front of the jury, in rebuttal, and at the close of his summation, he goes back to the improper specifications even after he had been upbraided by the district court, because he knew that those things would move a jury. He knows, as well as any lawyer in this room, better than most, what motivates juries, and that's the best evidence for prejudice that we have in the entire case. If I may, I would also like to talk briefly about the expert witness issue. In argument and in PowerPoint slides, the plaintiff's lawyer called a high school classmate of the plaintiff an expert 10 times. You'll see this at page 18 of our brief. There are literally head-to-head comparisons of Ms. Lubin, a lay witness, and the expert witness, Mr. Lawrence. Mr. Lawrence had very powerful testimony that showed that with 13 seconds before impact, but just 3 seconds before Mr. Takes starts turning his truck, Ms. McQuillen, the plaintiff, is manipulating her phone. In motion, she is manipulating her phone, and so the plaintiff never discloses an expert witness to rebut that testimony, never discloses Ms. Lubin at all, but then calls her, and had nothing happened in closing argument, that testimony would have passed in and out as a lay observation from a pleasant witness. But what Mr. Rodriguez does is he elevates her to the level of expert witness. Yes.
I think your brief concedes that her testimony was of a technical kind, of the kind that an expert would give, and that's part of your concern, that she was not disclosed as an expert. And so, for all practical purposes, she spoke as an expert, and there were no objections. Am I correct in that?
Objections to the testimony, but the term expert is never bestowed on her in the course of her testimony. The thing that causes the prejudice is when Mr. Rodriguez bestows the expert title on her, comes up with this head-to-head comparison, uses her testimony as expert testimony. She's not a percipient witness to what happened to Ms.
Testified to is not the objection, just the category that the attorney gave when summarizing her testimony? So isn't there a curative instruction that has to do with lawyers are not evidence, what they say is not evidence?
Yeah, so that instruction is in the case. But again, Mr. Rodriguez, this comes out, you can see this off the page when you read his closing argument. He was, at the time of that argument, 70 years old. He had been doing this for many years. He presents as a wise, plain-spoken, avuncular guy. The jury trusted him. They didn't think that he was going to mislead them about...
Instruction about experts and how to treat expert testimony?
Was the pattern instruction, it's instruction number 5 in this case, which frankly creates the problem. That instruction, this court should review it, in one breath it says, treat experts just like every other witness, and in the next sentence it says, but they're not like every other witness.
Have with this aspect of your argument, Mr. Weinhardt, I mean, it strikes me that Ms. Lovin, is that her name? She kind of did get expert testimony into the record, and it wasn't objected to. So then, in closing argument, Mr. Rodriguez calls it what it was, expert testimony. But the train left the station when there was no objection to her testimony, right?
I don't think it is identified or identifiable by the jurors as expert testimony until he says as such.
Testimony before I read all of that, and she's like my kids, they know their stuff. I mean, she'd used it. Didn't the defendant's expert had ever used Snapchat?
He had not used Snapchat.
Fox would be like, what? And then you listen to that girl talk. So my point is, I didn't have to hear her called expert to think, dang, she knows what she's talking about.
Except that she doesn't. There's no dispute in this record that she is not qualified to testify about digital forensics, and there's no dispute in this record that what she said did not substantively contradict the accuracy of what Mr. Lorenz, the digital expert, testified to. The manipulation of the phone with 13 seconds to go, that's not contradicted.
Federal system, they're looking at a rule of evidence 707 that would make it harder for that kind of testimony that she presented to come in. But the point is, it came in, right?
Yes, it came in, but that does not authorize and sanitize blowing it up in mushroom cloud size in front of the jury and using for the first time ever the term expert. That was the error here. And the other thing that I would say is the prejudice is cumulative with the prejudice in the first division of our argument. In other words, both of these things go to the fighting issue of the allocation of fault between the two. Yes.
So if the standard on prejudice in a negligence case where there's comparative fault is, would it make a difference in the allocation of fault? How far does that go? Because that's not usually how we think about prejudice in this context. And it seems like very small things could make marginal differences in terms of the percentage allocation of fault. So how do we kind of navigate that without requiring new trials for everything, where there's some prejudicial comment that swings the percentage 1 or 2 points one way or another?
2 points is $250,000 or $500,000 in this case, and so small gradations have a significant impact on the parties. But that said, there's no dispute from the plaintiff that is the law applicable here. And the only authority cited by either side says that you do look at the effect that it has on the comparative fault allocation. In this case, we believe that the comparative fault allocation between the error of the specifications of negligence and the Lubin error was powerfully affected. This isn't a question of whether the court has to agonize over, gee, maybe it swung 2 or 3 points. Is that enough for reversible error? We think that this was a major swing. Without these 2 errors, this very well could have been a defense verdict, and that's easily enough to meet the prejudice standard in this court.
Step away, could you address whether there was reversible error that was preserved on the present value issue during closing?
Direct this court to actually pages 64 and 65 of the plaintiff's brief on the preservation question. So first of all, there is a little used but completely proper procedure to file a bill of exceptions to put into the record what happened in something that was unreported, which unfortunately the logistics of the Linn County courtroom were such that sidebars were not reported. The defense, at their earliest opportunity, properly pursued that procedure. I think that's enough, but then in the hearing on the post-trial motions, the district court described what it was that he ruled, and that's what's quoted in 64 and 65 of the plaintiff's brief, and he said that he stopped the defense from talking at all about the concept of an investment because in his view, an investment is a thing you could do with the money just like buying a house or an expensive car or something like that. And that's just not the case. It is literally impossible to talk about the concept of time value of money or present value, which statutorily we're required to do, without talking about the existence of a hypothetical investment. His own description of what he prevented in that post-trial motion hearing makes clear that the defense was hamstrung on that issue.
For just a moment to the Snapchat person and whether or not a different verdict was probable. Couldn't that gal have been qualified like Marissa Tomei in My Cousin Vinny? I mean, my goodness. I mean, my point is, don't you think she probably would have qualified for an expert? And if so, okay, they just didn't do their homework beforehand, but it doesn't change what she testified to. I mean, a kid, a 16-year-old can, and they are experts in certain areas. So really, is a different verdict probable with that Snapchat deal?
So first of all, because the conduct of the plaintiff in using her phone as she is hurtling towards the intersection is probably the most important aspect of comparative fault. Yes, I think a different verdict is probable for either of those 2 errors. That's number one. Number two, she wasn't qualified as an expert. She admitted she had no experience in digital forensics on cross-examination. Number three, this isn't a question of homework. Notwithstanding our initial disclosure requirements that say you have to disclose at least the identity of witnesses whose evidence could be presented to assist your case, she wasn't even identified in the initial disclosures. Not only is she not disclosed as an expert, which if you're going to be Marissa Tomei in the real world, you have to be disclosed as an expert, she wasn't disclosed as a witness at all. She was a complete stranger to the case when she hits the witness stand. The defense has no idea what it is that she's going to testify to. Under those circumstances, I think putting great burdens on the defense as to how they were supposed to react to that testimony is just not fair.
May it please the court. Before we focus on what the court described as a very small portion of plaintiff's argument that was improper, I want to point out a few obvious facts. First of all, over this 2-week trial, there were 12 expert witnesses who testified. There's no alleged misconduct. There's no evidentiary errors involving those experts. With regard to instructions, no objections by the defense to the instructions, not on appeal. With regard to the size of the verdict, there is no appealable error. The court found there was sufficient evidence to support those categories of damages. No evidentiary issues on appeal. And the court concluded at the end of this case that misconduct's alleged. Thanked the attorneys for their professionalism at the end of the case. So now let's focus on this very small portion of what the court found was the improper argument. And to put it in perspective, first of all, the court read the jury instructions before arguments. Second, each juror had a copy of the instructions in front of them. And most significantly, here's what the court said after reading all of the instructions. Quote, on instruction 16, I did note as I was reading it, I was missing a word. If you return to instruction number 16, I will change that on the official copy you are going to get. There should be an or after 1B, and I did read that. Failure to yield the right-of-way upon a left turn, or fail to maintain a proper lookout, or fail to discontinue operation of the vehicle under hazardous conditions. So I will add the word or there on your official, and if you want to add it with your pen, you can do that on your copies. And then the court said, so at this time, counsel will present their their arguments, and arguments, quote, are not evidence, and they should not be construed by you as evidence or instructions of the law. And that's the context of the instructions when we start closing arguments. That instruction goes back to the jury room. A demonstrative exhibit used in argument does not. But that's the context in which the court found that this small portion of the closing argument was not prejudicial.
It was mighty. It was, because you wanted it in, they wanted it out, they got it out, but it came in as far as on an exhibit. Can you explain to me that time lapse between court ruling on you guys wanting speeding and parking, whatever it was, into the instructions or into the evidence, and the judge said no? When did this exhibit then face the jury?
This was never an exhibit, Your Honor. This was just...
Excuse me. But how much time transpired between the judge's ruling and what I call go time, which is now we talk to the jury?
At the transcript, the argument involving the slide that is at issue is on pages between 10 and 12 or 13 of the transcript. The motion for mistrial is made on page 36. And the motion for mistrial is 2 sentences.
So when did the judge rule it doesn't come in, and then all of a sudden it came in through argument?
Right.
How much time? When did the judge rule? At what stage of the game? Either that same day or earlier, or motion in limine? I'm not sure. When did the judge say, I am going to do a directed verdict on anything that has to do with speed or parking? You're not going to get to talk about those things.
The verdict was earlier that day.
Hours?
And I can't remember, Your Honor, but there was not a significant amount of time.
You know, I'm guessing these slides were probably prepared in advance, and maybe they were prepared with the eye that those 2 claims would remain in the case. It doesn't really alter Mr. Weinhardt's argument, but it maybe somewhat diminishes the contention that it was done in bad faith.
Reason, I think, of what happened is there wasn't a change.
Also know from my experience as a trial judge that oftentimes those rulings are made and then everybody gets to go home and the judge gets to go to sleep that night, but the lawyers are furtively working on all their stuff for closing argument. And that probably would have allowed someone an opportunity to say, oh my gosh, I got to take that out. And I'm just wondering, was it same day? How much time? It matters to me as far as mistakes or intentions. So you don't know for sure the amount of time? Same day though, for sure. Same day?
It's the same day. But I am not sure on that.
Found that the argument was improper because the closing argument was identifying specifications of negligence that were not going to be presented to the jury, right?
Yes and no, Your Honor. The word specification was never used in closing argument by either side. And
the district court did find this was improper argument.
this was improper argument.
Assuming that it's improper, was it an abuse of discretion not to grant a new trial because of the potential prejudice, in particular, the allocation of fault between the parties, right? So what's the best argument that this is not prejudicial, given the way the closing argument was presented?
In context, when the closing argument is made, the jurors actually have their personalized marshaling instruction in front of them. They have that during the closing argument. And the part of the argument that the court found was
Written, or not handwritten, the hard copy of the instructions is in their laps during oral argument. Who reads them while somebody's talking? First of all, I never gave them to them. I didn't want them to have them in their lap. I didn't want them distracted. But if I had done that, I'd be shocked if somebody was reading that because it's not the most interesting read. I'd way rather listen to a lawyer give a closing argument. So do you really think they're tying up while they're listening?
we presume under Iowa law that jurors follow the instructions. And they had the instructions. They only had it not only read to them, they personalized it, and they take it back to the jury room with them. They see the slide in the argument, and we're to presume that that is prejudicial in weighing all of the factors. In the entire trial, and that's what the judge looks at to determine prejudice, the entire trial and what happened during this entire trial. And the court found that it was only a small portion of a lengthy closing evidence, and otherwise evidence was very strong of negligence. Where this or argument came in was after he talks about the fact that the defendant testified this was the most dangerous turn you could take driving this truck, and pled guilty to failure to yield. And he said, we could stop right there, because the judge said or. And then he continues on with the argument. The fact that on appeal they have magnified this. Keep in mind there was not a single defense objection during the closing argument. After the break in the plaintiff's argument, when the two-sentence motion for mistrial was made on this issue, not a single objection after that, not a single motion for mistrial, no further record whatsoever by the defense. And now to say,
they don't have to make an objection. They've objected timely under our case law. The issue is preserved. I'm not sure what stomping up and down about it adds to the legal issue.
Your Honor, I agree with that. But when we talk about the argument as a whole, we put everything in context. I think it goes to that. We look at Kinseth, there were 5 sustained objections during closing. There were 5 violations of motion in limine. We don't have any of that here. And that's my point.
I understand the issue about maybe changing a PowerPoint. I guess that doesn't seem terribly hard at the last minute. But the plaintiff emphasizes, unless I'm misreading this, I'm looking at the PowerPoint slide that's got the one with the dominoes falling over. And he says, isn't the most important thing, the first domino, the thing that triggers it all, is this parking issue, right? And then he talks about it in closing, and then he ends the first argument with that. He's admonished not to do it, and then on rebuttal, he comes back and starts talking about the same things the judge told him not to talk about. And then there's also pictures, right? There's speeding was not a specification of negligence, right?
It's not. It's part of the evidence.
There's a slide after you get to the part about speeding that has a picture, I think, of the dash cam with the speed on the top. I mean, that slide could have been pulled out very easily out of a slide deck without altering any of their slides in the deck. And I find that a little bit problematic, where an attorney is clearly pushing the boundaries of oral argument, kind of with the thought, well, you know, judges don't grant mistrials very often, so I'm just going to keep going. That's what it looks like to me from this record.
Response would be, in contrast to talking about something that is in the evidence, if you want to construe it that way, everything that was discussed was about evidence. The speed was part of the evidence. After the motion for mistrial, there was never any reference to, we have to prove that as an element. Was it part of the evidence? Yes. Just like the whole parking issue was part of the evidence. And it starts there in terms of the theme being They didn't care about safety.
It was in the record, but he told the jury, if you find, and he goes through it systematically, if you find this thing, and then he has the checklist, and then a couple of pictures to illustrate the point, or if you find this thing, and then he goes back to the checklist, and then he has pictures to illustrate the point, and he keeps telling the jury, just one, or, and he makes that statement. So, yes, he's talking about evidence in the record, but he's telling the jury the way you look at it is if you find any one of these 5 things I talk about, then that's a plaintiff's verdict, and that's just wrong. And it's clearly wrong and contrary to the judge's instructions in the case.
Look at what he said. It was, quote, because the judge read to you, the instruction said, all you have to do is prove one of these things. Do you remember he said or? And that's referring to the instruction. You know, here's the point.
Here's what he says. Here's another piece. We could stop at any one of these, but there's even more. Did he violate company policy requiring authorization to park his truck?
And that's all before the motion. You're right, Your Honor. That's all before the motion for mistrial. My point being, if this were prejudicial, it was never brought up in the defense closing argument.
That you brought up and the other side didn't. I have it in my notes as negotiated finality. It kind of reminds me of you can't pay for peace and keep fighting the war. Can you talk about that one?
Your Honor, that there was a settlement that, if that's what you're referring to, and that is that West Side, unbeknownst to us at the time, was up for sale. They had a pending sale agreement, and their personal attorney wanted this resolved. There were discussions over and over about getting it resolved. And in response, there was a letter sent saying, in order to get the satisfaction of judgment that you need right now for this sales agreement, here's what you need to do.
Let me ask this. Is there something in the record that says that the right to appeal is being abandoned or given away or waived through a settlement process?
Never any reference to an appeal before that time whatsoever. There was no reference to reserving rights of an appeal before that letter.
Problem. As I read, there's this October 3rd letter and the October 4 letter. Is that's the gist of what we're talking about? So the October 3rd letter is addressed to the counsel for West Side and to all these different insurance carriers that I guess were providing different layers of coverage in this situation. And it's, hey, you all, you know, here's what it will take to resolve the case. You get a letter back from West Side saying, you know, essentially West Side is on board and it has directed its insurance carriers to immediately pay their limits. Well, I've seen that before. I mean, that tells me there's still something going on between West Side and the insurance companies, which in fact there was. And I don't think you can make an offer to 6 folks or 5 folks knowing that it's got to be, you know, those 5 that sign on and then get a response from one and say, hey, I've got a contract. It's an offer and acceptance issue. You see what I'm saying?
The acceptance was by West Side. The acceptance was by West Side, and they directed the carriers to pay the settlement checks pursuant to their limits.
You know, but the offer was made to a group. I mean, you know, we know contract law. It's offer and acceptance. This is an acceptance for West Side saying, I'm going to tell the insurance carriers to pay their limits. And again, you know, we've all practiced in this area. You know how that works. Maybe they will pay, maybe they won't. That's how it works.
Here, Your Honor, is West Side paid the excess over the insurance. They wrote a check for $12.5 million. And they told the carriers, pay your limits. 3 of the carriers, 2 of them had settlement on their check. The other one had, in a correspondence as part of the attachments to their resistance, said, we can't get the settlement check that fast. The 3rd layer of insurance, which is holding this appeal, is the only company that somehow said, well, we're going to retain our rights to appeal. All I can say, Your Honor, is it comes out of that one phrase in West Side's letter to the carrier that says, but we're reserving all our rights against the carrier.
Counsel, was there anything given up in this? Typically, if you're going to settle, you get something for it. What did they get for it?
They got immediate satisfaction, even though everything was not going to be paid. We were required to hold the money in trust. There were conditions on that. And Iowa law only requires consideration on one end. We gave up the right to execute, which would have interrupted their business, potentially the sale that's going on, and that was the important point to them. We gave up that right, and we had to hold the money in trust.
If you read the October 3 letter, the very letter suggests that the plaintiffs knew that this was a deal that had to be signed off on by the insurance companies in addition to Westside. It was a group offer to all of you. And Westside said, well, we're accepting and we're instructing the insurance carriers to pay their limits. Okay. That, they're not bound by that instruction. They, that's, and,
Interpretation, Your Honor, but the fact is that Westside could have also written a check for the entire judgment is what typically would happen, or you would have one insurance company that would do that. They had the ability to bind Westside, and they did. They could have made the entire check payable, and we wouldn't have this issue. But they assumed, as far as we know, and had authority to assume, that those insurance companies were just going to give their checks like they were instructed.
I think you were about to talk about the defense closing argument or the opportunities, and I'd like to hear your answer on the specifications and negligence.
Now, clear abuse of discretion. The court gave suggestions at the time of the mistrial to say, you can easily address this. You can easily put up the instruction. You can talk about these things. And if you look at the closing, the defense never talks about either the slides or the specifications of negligence on the part of their own driver. They completely don't address that. And in the defense closing argument, I did make an objection. I did make an objection before something was put up because it would have been so prejudicial you can't unring the bell on that. And that was part that was left out. But there's a record of that as well. When we talk about the defense closing argument, they didn't even talk about Grace Lubin. Her name never shows up in the defense closing argument. And so the two closing argument points that they say are so prejudicial, they don't even address in their closing argument. I hope that answers your question. I see my time is up. If I may summarize in just one sentence.
One more question for you, if you don't mind. Could we go over the issue of the damages argument and what limitations were placed on the defense in terms of the present value?
I can tell you, if you look at the court's ruling, there were no limitations, none, other than they could not argue what the court ruled in limine. And what the court said was, defense counsel acknowledged at sidebar that the slide would be shown in connection with closing argument to the jury about McQuillen investing the funds. The court said, you can't do that. And if you look at the post-trial ruling, it says, I never said you couldn't make a time value of money argument. You just can't make that one. There were no other limitations.
On this, as I read the court's statements and also the statements of defense trial counsel, there was an objection to slide 33. I don't know if I'm dragging you too far in the weeds on this, but there was an objection to 33, and that is referenced a couple of times, and the district court says, I said they couldn't use 33, and that because of the limine ruling, right? And then, but again, as you said, there were no further limitations on the, that's your representation, correct? Okay. And so I think there was another slide, 34, that went into damages. Plaintiffs are requesting was what was its title, and it looks like, from how I understand the transcript, that was skipped over. There was no discussion of like 34 was not. He went to the the transcript suggests he just skipped ahead to 35. And I guess that was defense lawyer's choice.
What's on slide 34?
Right.
And as the court said, if this was so important, there was no record ever made before submission of the case to the jury. The sidebar wasn't reported. They had the opportunity, and that, I think the court, if you read the post-trial motions, the court was very frustrated. Their argument was even made because they had every opportunity to make a record. And I want to be very clear. The defense elected not to argue damages. There were no restrictions other than that one. And that's really what we're here about, is they want a second bite of the apple. Without ever saying it, that's the elephant in the room. They want a second bite. They didn't argue damages. Their strategy failed. And now they're looking, frankly, for a Hail Mary. That's what it comes down to. I think my time is up.
Yeah, your time's up.
Just one comment. And it's because we're looking at this clear abuse of discretion and whether a different result was probable. What the court said in its ruling is the court cannot find that it is probable that the result of trial would have been different absent the improper argument. The improper arguments were a small portion of a lengthy closing argument. Evidence of negligence was strong, and the jury was properly instructed that counsel's argument was not the law, and also properly instructed as to the grounds upon which they could find Takis negligent. And it's that finding and the thorough reasoning and rulings of this district court that require deference and require us to look at the record as a whole and trying to ascertain whether there was any prejudice. Thank you on behalf of the McQuillens. We submit this should be affirmed. Thank you.
Weinhardt.
While we were back at council table, we had an opportunity to look up the record. The directed verdict record was made the day before closing arguments. You'll find that record at the end of volume 7 of the transcript. The closing arguments are in volume 8. They had overnight to change their PowerPoint. They didn't do it, which goes to my point that this was on purpose. That's why it's prejudicial. Mr. Rodriguez knew that what he was going to do was going to move the jury. Mr. Novak finishes where he started with this idea that the improper argument about specifications was a small portion of the argument. It was not, we would submit. Remember that I talked about dividing the closing into 4 sections. If you look at the section, the first one, having to do with Takis's negligence, this is subjective. The court can make its own judgment. But in our shop, we tried to count up the lines of argument that went to the proper specifications versus the improper specifications. And what we get is 88 lines devoted to the proper ones and 95 lines devoted to the improper ones. So in the area of discussion of what Takis did wrong, the improper argument predominated. The argument is made, well, there's this instruction that says the arguments of counsel are not evidence, they're not the law. So it's sort of, this is what usually happens in instruction error cases, that the guilty party says, oh, they were instructed to ignore it. Closing arguments don't mean anything. Well, of course they mean a lot, and sometimes they mean everything. And I would commend Mr. Rodriguez's very persuasive argument to review with the PowerPoint, flipping through it as you go along. The court will see just how important closing argument was and how the jury is not going to be insulated from that by a boilerplate instruction. And indeed, in the Kinseth case, this court held that those boilerplate instructions were not enough to insulate a claim of error and a requirement to reversal. And if they were, then plaintiffs' attorneys, or well, attorneys on both sides, would have no incentive to restrain their argument whatsoever. Everything is harmless error. They can get away with whatever they want. This, I would submit, is even worse than Kinseth. In other words, violating the specifications of negligence, leading the jury to believe that even if the only thing that Takis did wrong was he was speeding at a place disconnected in time and space from the accident, that's enough to find a verdict against him. That, I submit, is worse than violating the motion in limine in Kinseth. And remember, the district court found that this was improper twice, once at the mistrial colloquy and once at post-trial motions. The argument is made about the defendant should have done this or that on closing argument. Those are always a Hobson's choice, whether you go back to the error to remind the jury of it and to dignify it, or whether you do something different. But it's not essential to error preservation. Error was brought to the attention of the district court. The district court understood it. That's all that was required under our law. With regard to the motion to dismiss, experienced lawyers know what it looks like when parties intend to settle a multi-million-dollar dispute. This ain't it. In Iowa, unlike other states, a satisfaction of judgment does not extinguish the right to appeal. That had to happen separately through a communication between plaintiffs and defendants in which they both agree that the right of appeal is not being given, or is being given up. And when I say defendants, I don't just mean insurance companies, of which there are only 2 of 4 that said what they say is important. I don't just mean Westside. I mean our client Clifford Takis, who had a say in whether or not a $26 million jury verdict against his name should be appealed. There is nothing in the papers that says that Clifford Takis agreed to foreclose the appeal that I'm arguing right now. Some Friday morning, a few weeks in the future, this court is going to issue a ruling in this case, and trial lawyers across the state are going to click on it soon, and they're going to find, because they're going to want to read, what are the guardrails, what are the rules? This court is going to send a powerful message to the trial bar if it reverses this case. It's also going to send a powerful message to the trial bar if it affirms this case. And so the question this court has to decide is, what message does it want to send? The message is, in Iowa, we have rules, and lawyers who want to hold on to their victories need to obey those rules. Thank you.
Of McQuillen versus Westside is hereby submitted. We will have a brief pause while the parties get ready for the next case for oral argument, which is Streeter versus Dunn Trust. The bench for just a few minutes. We'll be right back. Didn't wait for my colleagues. Thank you, everyone. Please be seated. Our next oral argument for the morning is Streeter versus Dunn Trust. And it looks like the parties are ready. It's my understanding regarding the appellants that the amicus is going to take the first 5 minutes and Mr. Kidd the remainder, and we will leave the timing up to you guys.
May it please the court, counsel. My name is Hallie Kissel, and I appear as amicus curiae on behalf of the Iowa Department of Natural Resources. I will use my 5 minutes to address DNR's narrow but critical interest here. When land is dedicated to the public and falls within Iowa Code Section 461A.112, the state is charged with protecting the public's interest in that land. Once the state has exercised jurisdiction, that land is held in trust for the public, and law and public policy require notice to DNR before that land's title can be quieted. And even when jurisdiction is uncertain or ultimately not exercised, notice is still required so the state can determine whether public rights are implicated. DNR is not here to relitigate this private dispute, but we are here because the district court adopted a rule that even when DNR has exercised jurisdiction over public land, or reasonably may have, it does not have an interest and it need not receive notice in a quiet title action. That rule is contrary to statute, precedent, and the public trust, and it threatens public land statewide. We are asking this court to clarify that when DNR has exercised jurisdiction over Section 461A.112 land, that it does have an interest and it must receive notice, and even when jurisdiction is uncertain, notice is required.
I'm a little bit confused about your position. Page 11 of your brief, it says, DNR did not get involved in the district court's proceedings because DNR has never exercised jurisdiction over the road. So what is the argument you're making?
The argument we're making, yes, that's correct, that we did not exercise jurisdiction over the road, but the district court did not limit its holding to this road. It said that even when DNR has exercised jurisdiction over public land, that it does not have an interest and not entitled to notice. So we're more concerned with the future cases of this legal principle being adopted and applying when the state.
Particular case, it's quiet title with respect to these roads, correct? And you've not exercised jurisdiction over the roads, correct?
Honor.
So you're not legally entitled to any notice, correct?
We would argue that public policy would support that we do get notice even without jurisdiction. Because the objective of a quiet title action is to determine all conflicting conflicts and to remove all clouds of title from the complaint. And so,
are telling me that you have no legal claim to these roads. You've never exercised jurisdiction over the roads. So why would the state be entitled? I mean, you're conceding you're not entitled to notice. I'm not sure why we should set aside a judgment because you think it would be better practices if you had notices about property you're not exercising jurisdiction over. I don't understand.
Your Honor, yes, we do assert that we do not have jurisdiction, but I guess what we're here to talk about today is the broader implications of what the district court's ruling could have, because it did not limit its analysis just to the road itself. And so we're asking that when Section 461A.112 land creates a cognizable, it does create a cognizable state interest once jurisdiction is exercised. And so at that point, the public land becomes a trust that's held for the public. And this court's decision in Marksbury confirms that understanding.
I mean, I'm with Justice McDonald. I'm really having trouble following DNR's position. So you're saying that DNR really doesn't have any interest in this road. Is that what you're saying?
We do not exercise jurisdiction over the road.
All right, but I mean, does that mean, then whose road is it?
The lien revealed that it was held to the public, the title here, at docket 65 at page 2.
Owns it, but the state doesn't own it?
We do not exercise jurisdiction over it.
The state or just DNR? So it's just out, it's, so it's,
Exercise jurisdiction over it, Your Honor. So once we exercise jurisdiction over public land, then we possess classic incidences of ownership. So that would be management, regulation, maintenance, and control for public use. And so Iowa cases do recognize that ownership and not paper title alone trigger notice obligations for quiet title proceedings.
This way, and you tell me if I'm wrong. My sense is what you're getting at is the state doesn't have a stake in the resolution of this particular dispute. You just want to make sure that when we write an opinion, it doesn't say anything in future cases that could prejudice the state where it might actually have an interest in the disputed issue. Is that fair? Okay.
And I see that my 5 minutes is up, so we are just respectfully asking this court to reject the district court's narrow conception of interest, reaffirm the Marksberry case, and clarify that notice to DNR is required whenever.
required, except in your view, it's only public policy that requires the notice? There's no statute or law that you can point to that requires notice?
The statute 649.2, when it's talking about the petition for quiet title action, it talks about claims adverse to the petitioner. And statutes for quiet title actions are remedial in nature and are supposed to be construed liberally. That's the Bates v. Bates case. And so public policy, we say, supports notice, but also just the objective of quiet title actions, where it's to determine all of the conflicting claims and to remove clouds from that title adjustment or of land.
Is the order here in error, but it's harmless error? Is that sort of what the state's position is? That the district court's order was wrong because the state perhaps should have had notice, but as it turns out, the state really didn't need notice because it doesn't claim jurisdiction? Or is there something else? Is it that the state doesn't have jurisdiction, but it claims some other property interest, that it claims some easement or something like that in it, that it still needs notice?
I think you're correct in your understanding of what we're claiming here. Just again, as Justice McDonald stated, we're asking that the legal principle and rules that was adopted by the district court doesn't carry forward into other cases, and that DNR should get notice when they've exercised jurisdiction, or if there's a reasonable basis to believe that they could have exercised jurisdiction.
Other than DNR?
I believe since we're just talking about section 46A.11 to land, DNR, it would just be noticed to DNR because they are the ones that exercise jurisdiction under the statute.
Because if if it's property that belongs to the public, which is your position, and I'm not a DNR lawyer, but I know a little bit from this job about quiet title. It says, the quiet title says, defendant makes or may make some claim adverse to the petitioner. If it's public land, should they just be notifying somebody at the state, some attorney general or somebody before they try and claim it? Or you're just talking about DNR? You're not advocating for the rest of the state?
I am just here talking about DNR, but we would say that notice is simple and inexpensive and routine, and so it should be given.
A good enough reason, you know that. You need a law. Yeah.
I would say that based on the statute 649 that talks about giving notice as well as quiet title actions, and the law that I stated about that the quiet title statutes are to be construed liberally, as well as when we're talking about quiet title, we're trying to identify all adverse claims.
Sorry to eat into your time. I'm sure we'll make it up. If this case were reopened, my understanding from your brief is that the state would not make any adverse claim, that they would not participate in this proceeding.
That is correct, Your Honor.
The resolution of this particular case, and I understand the state's concern about the court having stray language that would prejudice its interest in the future, and et cetera. You're not taking a position in this case because even if it were to be reopened, the state's not making an adverse claim. So we would be opening the judgment from the state's view for no reason.
Your Honor,
It's not future cases, I understand.
that in the opinion that's written or the decision that's given, that you would clarify what we've asked, that if land is dedicated under section 46(1A).11(2), that if we have jurisdiction, we're given notice, which is the district court said, we don't have an interest.
If this judgment were to be undone, the state's not going to make an adverse claim in the next round of litigation because you're not making a claim to these roads. Or sorry, the DNR, let me be more precise.
The DNR would not, as we've said that we don't exercise jurisdiction.
In our opinion, what would you write regarding land dedicated to the public where the DNR or some other state agency did not exercise jurisdiction? Is notice required or not? And if so, when?
I probably won't say it as eloquently as you all will write it, but that because the objective of quiet title is to determine all conflicting claims, to remove all clouds of title from the complaint, if there's a reasonable basis to conclude that DNR could exercise jurisdiction over the land, then notice should be given under public policy as well as objective of quiet title actions and the statute itself.
Look for to decide whether there's reasonable grounds to believe that even though they haven't exercised jurisdiction yet.
I believe it would be an objective analysis, and so things that could include that were included here would be like recorded plats or dedications to the public, DNR signage, maintenance activity, if it's adjacent to DNR managed land under the statute, or any prior engaged or litigation or enforcement under DNR.
Kid.
Thank you. May it please the court. My name is Dalton Kidd. I represent the plaintiffs in the matter, which are several of the lot owners in the plat of Tribogie Beach. As the record shows, the plat was done back in the 1920s. I believe it was 1929. And it created a lot of different lots. It also created blocks, lots, parks, beaches, streets, boulevards, and drives. Some of the language that is specific in the actual plat states the beach shown as Tribune together with the parks, boulevards, and drives are hereby dedicated to the public for use as such, and the beach shown as Tribogie Beach with the waters marked lagoon are hereby dedicated to the public use on as such. I get the court's concern regarding the state, the DNR, and who actually should be getting notice in a claim like this. This is kind of a unique case because this road, this Lakeview Drive, there's been a couple other cases. There's the Marksbury case, which was in 1981 about the beach, and then there was a case that was filed within a couple months, actually a couple months before this case with Lakeview Drive for the park. In that case, the Appellees, the Dunn Trust, had filed a quiet title, published notice, said that there's unknown claimants, and then successors to the Tribune Company that was the developer, and thought that the publication of notice there was sufficient. I guess our position partially is regarding the state or the DNR about whether they exercise jurisdiction. They should be received notice so they can determine if they have exercised jurisdiction or that if it's an open question, whether they could.
A claim, right? And normally you want to notify people because if they're not notified and it turns out they do have an interest, the judgment wouldn't bind them.
And so the concern here, though, is if it doesn't bind, even if it doesn't bind the state, they get the quiet title. Luckily somebody found out about this. Otherwise, nobody in the area knew about it.
Our clients, is it the state of the record that this is basically like kind of a back road that all the neighbors use? Is that essentially how it works?
Originally, I will admit it's not. It does not have cement, but there are lots that are actually on this road.
Could have provided, it would have been feasible to plaintiffs to provide personal notice to the other folks that abutted this road.
They actually are acquiring title to part of the road. I would say they're doing the whole width of the road, but they're not doing the whole length. So I think that the reason they were doing this is they did it only as far as the park went, because that's what they had originally quieted title to, and so they went there. But Esther Dehaan,
your position, and you think the record supports, is that the plaintiffs were on notice that these various people would use the parts of the road that the plaintiffs were trying to quiet title to.
at the hearings was that showed that people had been using this road for quite some time. In fact, the park that was I'll call it the second one. Marksbury essentially was the first one, and then they did, although that was a different estate in Marksbury, who coincidentally was one of the successors of plaintiff here. The park case was like 3 months before this. And then when we found out about that, and then the state or the DNR fought that and they won, which we would argue is issue preclusion, as Judge Carl Peterson did in that case, say that there was irregularity or fraud, and essentially said fraud because there was no notice to anyone here.
On the DNR's side, right? The DNR was the party that brought that challenge?
They did as the same type of petition of fraud or irregularity under 1.1012, yes.
What is the property interest that your clients claim here?
So I think our interest is some of the, it's tough it should be difficult to quiet title to land that's dedicated to the public, because who do you serve is the...
Where I'm going, 649.1 provides that quiet title actions may be brought, quote, against any person claiming title thereto, though not in possession. And I get that your clients claim an easement, perhaps, right, because they're using it and have been using it. Is there any other different property interests that they claim or might claim?
I think I'd like to clarify on the 649.1 versus 649.2. 649.1, the title of it says who may bring a claim. So we would treat that as who, that's more about who the plaintiff is in a quiet title. If you look at 649.2, it says that defendants should be who make or may make some claims adverse to the petitioner. It does not actually say title per se as somebody that may make a claim against the petitioner. What we're really looking for here is notice, and like I said, some of the lot owners are on this Lakeview Drive. This Lakeview Drive has been, they put up a fence so you cannot go through that. Actually, that's the only, or the best way to actually get to this park that the DNR did win at the trial court under Judge Peterson's case. And then the other part, I guess I would say, regarding my client's interests, we're put in a little bit of a difficult bind because we can't obviously control the state or the DNR about what they exercise jurisdiction over or may in the future exercise jurisdiction over. And I believe this court in last session in 2025 did bring in the case about 1,000 Friends of Iowa versus Polk County Board of Supervisors, which was 19 Northwest 3rd 290. That is not in our brief. I believe that was actually decided during the time of our brief, so it was not included. In that case, while it's not identical, that case, the court did allow that people that were in the area of a rezoning issue did have standing to bring a claim to contest a rezoning of a property. Now, yes, this is not technically a rezoning, but it's a quiet title. I would say actually the quiet title even may be more detrimental because we're not going to be able to use this property.
Question. So the road, the plat is dedicated to the public. The road is for the public. It seems, I guess I want to know, are members of the public who are not adjacent lot owners allowed access to this street and they could use it if they wanted to? So from our perspective, how do you limit the people who are required to have notice? So for example, you're saying anyone who could use the road could get notice. I could drive up to Okoboji and use the road and access the lake that way. There has to be some sort of limitation on who personal service should be required to be put upon. How do we draw that line? And I take it some of your clients are not adjacent property owners, so why should they get notice versus me, for example?
I guess I would start with that that's the inherent problem of trying to quiet title to a public road, is where do you draw that line of where it is? I would say that my clients, or the petitioners here, they are plat owners in the plat that dedicated this road to the public. At a minimum, they should be able to get it noticed because they would be ones that have land in that area. You know,
Require notification of people the plaintiff doesn't know about, but your position, I take it, is the plaintiff knows about who their neighbors are. The Dunns know who some of these neighbors are, and those people who it knows use the property and can give notice to should be given notice.
one could certainly go on the Iowa Assessor's website and look up who the property owners are in the plat and do a search under, you know, plat of Tri-Bogie Beach and look up those parcels and figure out who the owners are. Plus, they did know that there was other people using the property. And one of the other contentions or problems with the quiet title is the Dunns even admitted at the trials that they did not own the property or have an ownership interest until they quieted title to the property. And so that's where Judge Peterson really did find that he felt that there was, he may not have come out and exactly said it, but some fraud there, because they're saying in a signed under oath petition that they owned the road. And they actually didn't. They knew of other people using it. They knew that the park was being done by the DNR in the state of Iowa.
The Dunns even said that they didn't pay taxes because, quote, you don't pay taxes on property you don't own.
And so I think the reason we used the petition to vacate under 1.1012 was, one, we found that the state of Iowa or the DNR had already won on that issue at trial, which was not appealed in the park case. So, you know, we're not going to reinvent the wheel there for that. That's something of what would already work, and it also allows us to get some issue preclusion on something that, I mean, the road is actually in between the beach area and the park, and so it's actually closer to the beach in more areas that the DNR has gotten jurisdiction on. I'm not sure who, you know, I will admit it's kind of a dirt road. It's not up to specs because nobody really, that's the tough part here for my clients is they don't want to own the road, or they don't own the road, so do they do that? But they've, you know, there isn't actually an association out there. I should say that there is an association, but it was not part of the plat that there was a homeowners association. It's more of a voluntary association that's been created over the years. So it is somewhat platted, you know, maintained a little bit, but it's mostly used in the summer. I've been out in that area a long time. It's a lot of, there are people that use a lot of cabins out there that's mostly for the summer to use the park there.
Clients have only access through that road to their properties?
Esther Dehaan, one of the petitioners, she lives on Lakeview Drive. Her house is, or her property is what I would call kind of north of the part of Lakeview Drive that is actually, that the petition for quiet title was. So essentially, she drives down this road. She has her property, there's another one, and then there's the park, and then Lakeview Drive is essentially cut off due to this, these proceedings. I believe it was her, another one, that's the only road in. There's no cul-de-sac to turn around in or anything like that. And so that road is used actually to access there. And if the Dunns are allowed to continue to do this, we have a public policy argument of, I mean, I know a lot of real estate investors that would be licking their chops. So we're just going to go find where the state maybe hasn't claimed jurisdiction or it's not clear. We're going to publish notice. We're not going to give notice to the state of Iowa, to the DNR, to the plat owners, and we're going to get title to these properties under the cover of darkness without anybody knowing about it. And then all of a sudden, some of my clients, the road is owned by somebody else that gets access to their property. Now, maybe they have an easement by necessity, maybe they have all this, but shouldn't they get their day to provided notice to actually contest this quiet title early on rather than after a quiet title and the ownership has already been established. I know I'm over my time some, but I'd be happy to answer any questions here.
Come back. How about that? Okay, Mr. Brown.
May it please the court. Our view is this quiet title action was properly filed by the Dunns. The state didn't own the property, didn't have a property interest. And DNR's in here arguing. There wasn't any fraud involved. There was notice by publication, which we think is appropriate. We think everything that was done was appropriate. And basically, we're a long ways out. This case is old. I mean, I
Languished for 3 years. I don't think that was the fault of anyone in this courtroom. But here's the thing. I mean, as Mr. Kidd points out, I mean, if this strategy works, what's to just prevent anybody from, you know, there's a road that has been dedicated to the public and they just file a claim that they've established adverse possession and give notice by publication, and you know, people don't read these newspapers anymore, and that's and then they establish title. I mean, does that seem like something we want to have in Iowa? This sort of people just running to the courthouse like that?
We have newspapers in Iowa, much in Iowa, but I think, at least it seems to me, there is such a thing as notice by publication. It's a valid way of serving process. And I think
I remember using publication, and I would have been happy to talk to any judge who wanted to challenge me on why I used publication. I honestly couldn't, either didn't have a name, or I didn't have an address, or I had tried, or they're evading service, whatever it may be. But you don't have any of that in this case to support why publication was used instead of another notice, especially for the plat owners.
well, I think I heard an acknowledgement the state doesn't own it. So I'm not sure how you saw that.
Ownership and use. I don't think you would disagree that there were a lot of people using that property, and that one stick of the bundle could be use. Ownership, of course, is all the sticks. But wouldn't you agree with me that those people had a stick?
I think notice by publication is valid. I think it was valid when it was done. It's valid right now. I mean, I don't know why that's not valid.
Valid if you know if you know the names of, let's say, other people who would claim an interest, who use the property to the same extent you do, and you know who they are and where they are, and you could give them personal service. Then it's not valid, is it?
Publication is valid in a quiet title action, and I think everything being equal, I think there was appropriate steps taken, and the idea that Judge Peterson suggested in his ruling, notice to vacate, filed in the other case, there was fraud involved. There was no fraud involved. The Dunns didn't exercise fraud or irregularities. They followed the statute, which quiet title action, they gave notice by publication.
Was fraud if you were entitled to personal notice, you were not, the service that you were given didn't comply because they knew who you were and where to find you and didn't serve you, then I don't think you have to say it was fraudulent. I think irregularity is sufficient. I mean, that's what we learn in, Penoyer versus Neff, or those cases we study in first year civil procedure, right?
Best of my memory, but I do think Judge reality is, I do think for Judge Peterson to suggest there was fraud involved by the Dunns, irregularities, there's no basis for that. So when that basically, the last ruling on the case, the one that was appealed from, was entered, it's appropriate. because I don't think they can establish fraud in basically anything the Dunns did. Nothing.
Why not, in order to address this concern about in the dark of night losing public lands, why not just simply require actual notice to the DNR or to the state whenever the Quiet Title Act land dedicated to the public,
Well,
even if they haven't done anything to exercise?
just that will have to be the ruling from this court, I suppose, but that's not the law now. They're not entitled to that now. They were given notice by publication, and basically, they've even entered arguments this morning indicating the state didn't own the property, they didn't have a property interest. DNR didn't have a property interest. Basically, where does this end?
Trust's claim to title.
I'm not sure I understood you.
They're filing a quiet title action, right? So what is the legal, assuming there weren't a default judgment, what is the theory upon which they would have title to a public road?
Basically, there's dedication, there's a quiet title action, and basically there's a default, and basically at that point, they own it.
Not a default, and this, somebody answered, somebody read the newspaper, filed a claim. What would be the legal basis for the Dunn Trust claiming title to the public road?
At that point, it was a dedicated area. Basically, they gave notice, and basically, I think at that point, it's in equity, and I think the court will determine whether or not they own it or they don't.
Under 649.1, we talked about earlier, who may bring action, it has to be someone claiming an interest in that property. What is their claimed interest in that property, in that street?
I think it's in their petition. They basically allege it.
Interest the same as everybody else who's the defendants? The plaintiffs in this action? Do your clients have any, I just hadn't thought of it that way as Justice McDermott just asked. You say it's in the petition. Can you tell me, what is the Dunn Trust's interest in this action that's greater than anybody else who's saying you should have given me notice? Just that they were first to bat?
I think the fact that they filed the action in quiet title, basically to remove any doubt, and I think they've done that.
What in the Dunn's situation elevates them to the level that they are the ones who file quiet title? Do you think the others, the plaintiffs, could have also filed quiet title if they beat him to the punch? Yes. And then your client wouldn't have gotten notice?
Yes, they could have filed a quiet title action.
And your client would not have gotten notice?
Oh, that's not, no,
Have gotten notice if somebody else did it?
it's valid notice.
Only if it says personal service cannot be, an affidavit that personal service cannot be had. Here, personal service can be had on other people within the development.
Certainly not everybody.
Nobody's saying that and I agree with Justice McDonald, you don't have to serve everybody who happens to drive down the road, but certainly the neighbors who've been using this road for years and years, who would find this fence put up, they would have an objection, and you know who they are and can serve them.
I think there's an assumption from the bench that they did know, and the fact is they didn't. The fact is that's why you do notice by publication when you don't know all that.
Not why you do publication. Publication, sometimes I used to do it as a bootstrap. I'd do it in addition to certified mail. I'd make attempts at service with the sheriff. It's a bootstrap. But publication was the last possible route. I can't do anything else. And in this case, I do think that certainly your clients could have given notice to someone else. But I want to go back to my question because I don't think you've answered it. If somebody else beat your clients to the punch, Streeter, let's say Streeter was the one to do this. Would Streeter have had to give the Dunn Trust notice? Why? What makes them any better situated than the Streeters?
Notice by publication would be valid there, and they could do it.
I said, would the streeters have to give your clients notice? I didn't say publish notice, because I think we've all agreed, you even said, nobody reads the papers. I'm saying notice the real way.
I said there are no newspapers anymore.
And say by publication. Do you think the Dunns would have been entitled to be informed, but not the streeters?
They'd be entitled to be noticed because everybody knows that the Dunns had an interest, yes.
What is their interest that's greater than everybody else's?
I think the streeters certainly, if they wanted to bring an action, they could have, certainly.
You're saying, but your client would get notice.
That's right.
It seems like the district court looked at 649.1 and saw a difference between who could bring a claim, anyone with an interest, and who the defendant would be against any person claiming title. Is it your position that you only have to give personal service as opposed to publication to someone who has an actual claim to title as opposed to someone who just has an interest? And is that inconsistent with 649.2?
I don't think so. Again, I've got 49.2 in front of me. It seems to me as long as basically, if you look at this, they had a right to bring the action, and basically, as far as credibly informed believes the defendant has any other interest, they basically give notice.
So it says the defendant forever barred from having or claiming any right or title. So it's not just limited to title, it's any right at all would be an appropriate defendant. Is that right?
Suggestion is title. Did they have title? And the state obviously didn't have title, and the DNR obviously doesn't have much of a claim on it.
That's what the district court, where they got hung up, that the defendant had to have a claim to title as opposed to just some claim of interest. Okay, and that seems inconsistent with 649.2, which talks about cutting off a defendant's claim to any right or title. So
Well,
why wouldn't any defendant that has at least a claim of right not be an appropriate defendant?
you need to read the statute as a whole, and I believe the only way it makes sense is that basically somebody owns it and has title to it.
I think it's the other way around, because otherwise you get what the chief was talking about, where you have various people use this road. Any one of them could go in and say, I have a claim of adverse possession, which I think is what they alleged is their basis for title. And then say, well, no, and then say we don't have to notify anybody else because as of now they don't have title. Although, if the Dunns have title on that basis, certainly all the other owners could have title on the same basis, and that can't be right. That it's just whoever happens to be, kind of clever enough or to go to court first, gets to, block everyone else from the road. That doesn't seem right, does it?
Anybody committed fraud. I don't believe the Dunns were being clever. I think they just filed a quiet title action and followed the proper rules.
Fraud is just, it seems like, we normally don't read statutes to allow odd results, and this seems like an odd result, doesn't it?
Peterson, when he basically ruled in the way he did, I think he basically found fraud, and I don't think there's anything indicating fraud here.
My point is, and I can't get beyond this, what's good for the goose is good for the gander. I want to make sure I understand it correctly. You're saying that if the Streeters had done the same thing your client did, your client would deserve more than publication.
I don't think I said that.
I'm not talking publication. And I said I'm not talking publication because I think the Streeters know that there's people to be in. But my point is, do you think your client deserves more than a newspaper service if the roles were reversed? So then we are talking about a race to the courthouse.
I don't see it that way. I think the rules provide for publication, no notice by publication. I think it's a valid type of service.
It's a priority. It is not, I mean, if that were the case, I'd have made out like a bandit. I'd have had so many cases by default judgment. I would have loved it if I could have been the petitioner or plaintiff in suits and just done publication. That is not the preferred method, and there's a priority. And you only get to do publication when you have checked certain boxes. And I don't think your client checked those boxes.
Have ever made out like abandoned. I don't believe that.
My point is, I said I would have. My point is, if you don't have to check boxes and can go straight to publication, aren't we subverting due process, opportunity for notice? Isn't that a problem in lots of different arenas, not just this case? Because you seem to be arguing that publication's the way to go.
It's in the rules, and I think it's still in the rules. And people do notice by publication all the time.
What, I'm just looking at the petition. Paragraph 1, they allege that they're the absolute owner of this portion of the road. Paragraph 2, they entered in possession, such possession having been adverse, open, notorious, hostile, and a claim of right for 10 years. So that's the theory of ownership, is adverse possession. Then paragraph 3, they say the defendants, plaintiff is credibly informed and believe may make some claim to said property or some interest therein adverse to the title of plaintiff, but plaintiff states that such claims are wholly without right. And the only adverse entity they identify is the Tribune Company from 1929. They don't, I mean, weren't they on notice that some of their neighbors would also make some claim to said property or some interest therein, at least the right to use it, right? You know.
What went on in the minds of the Duns when they filed that, I don't know. I obviously wasn't representing them at the time, Judge. But overall, I think it's interesting. We've had this case pending for some time. You take a look at how many cases have ever been decided under quiet title actions. There aren't very many of them. And the question, maybe it is time that it had to be revisited. And I'm okay with that. That's not an issue.
Mr. Brown. So typically when a default's entered, people have an opportunity before the entry of judgment, before the judgment's entered. It's typically kind of perfunctory, but the district court judge still has an obligation to make sure that judgment is appropriate in the case. And I guess setting aside the notice issues, I'm really troubled by the theory that a party can adversely possess a public road where the facts are widely known that people are actually using the road in addition to the Dunn Trust. So is the procedure here inappropriate to enter judgment on the default when there's, as far as I can tell, I mean, no disrespect to the Dunn Trust, there's no plausible legal claim to owning this road. They're not in the chain of title, and it's a public road that they're claiming by adverse possession. So did the judge have an obligation to at least review that before entering the judgment on the default?
I think he did. Obviously, it wasn't done. I can't speak for what the court did or didn't do. But in terms of whatever, basically, the background record on this case, I think it was pretty de minimis. And I don't know why they didn't do more than they did.
Thank you, Mr. Brown. Mr. Kidd, you look like you're going to be the one to do the rebuttal? Okay, thank you.
May it please the court. So I wanted to kind of follow up with some of the questions that were asked about Chief Justice. I think you had mentioned about first one of the courthouse. What about the situation that they both file within a week of each other? If they publish notice in the paper, maybe they don't see the other one. We could potentially have two default judgments with two different plaintiffs over the same property. Just under Iowa law, I mean, they're just in practicality, there's no way that could work. You know, I think one of the issues, you know, and I think Justice Mansfield, you brought up, you know, it is essentially an adverse possession claim of what they claimed in their petition, that they had this open and notorious, and they stated that under oath that they had that. You know, sure.
the application of Rule 1.1012, which says that you can vacate or modify a final judgment or order if there was irregularity or fraud practiced in obtaining it. I know that the parties have kind of briefed generally the fraud part of it. What's the irregularity part of it? What do we need to find to satisfy that? Are there factors, or is it sort of just a general dictionary definition?
I think if you look at Judge Peterson's ruling, he delineated about, I think there's like 5 or 6 different factors of what was considered irregularity. You know, that there was just kind of, I think it's a little bit of open question, because irregularity, we kind of want to catch all of, you know, because strange things happen in cases, we all know that you just, and so that kind of is a catch-all to say, this is not what the results should have been this way. There needed to be some sort of notice. There needed to be, you know, a mistake was done or something that's clearly that we needed to fix, and that's where the irregularity would come. I apologize, off the top of my head, I can't remember what those factors were, but Judge Peterson did do a pretty eloquent job of describing those. And regarding, you know, the tough part here too is, you know, what, you know, my clients, their claim to this is, as whether they're members of the public, members of the plat, potentially successors to the Tribune Company, as they are the ones that actually bought the lots, or they're the successor owner of those lots that were originally owned by the Tribune Company. They would be considered to me that they would be personal notice as successors, that would be clear that the Tribune Company sold these lots. It's gone down. Obviously, I shouldn't say for sure that some of my clients haven't owned that in their family since the original plat, but that they would be considered successors to the Tribune Company, and therefore, as lot owners, they would be the ones that would receive personal notice. And I just, you know, when we started looking at this case, the tough part is okay, one, yeah, who should receive notice here? I get the court's reservations on saying, you know, we can't have this completely wide open that anybody could come and make a claim. I would say that that's partly inherently the problem of doing this with public notice or publication and not giving notice to somebody. The assessor's page, I think it's in the testimony or in the record at least, that the assessor's page showed this owned by the state of Iowa when you click on the assessor's page. Now, yes, the assessor's page may not be the official legal bearing on that, but I think that gives you notice that, okay, the state of Iowa may have a claim here, and I think the due process under Iowa law would be that, you know, you're better off giving notice to more people that may have a claim than to try to cut this off, because then we run into these problems. You know, my clients, they're currently, I believe there's still a chain that blocks this access, and that access actually goes to the park. That's the easiest way to get to the park that the DNR did assert jurisdiction over. And I think that even if, I think it's very clear that the dedication was accepted by the public, by public use, which has been shown in Iowa law that would show it. So, you know, I'll be honest, I'm a little unclear who would be considered the owner of it. I still think it would be the state of Iowa that would receive notice, whether that's the DNR, whether they would do jurisdiction over it, or potentially what could happen if the state of Iowa or the DNR has received notice, they could talk to, you know, an association or the landowners in there, at least give them notice about, hey, what do you want to, is there any consideration here that we need to look at? And with that, I would submit our oral argument and request that the district court's rulings be overruled. Thank you, Your Honors.
This Dunn Trust is hereby submitted, and court is adjourned for the morning.